Good afternoon. Thanks for joining us for today's program from LP2, the Lifelong Peer Learning Program of the Postgraduate Degree Conferring Institute of the Graduate Center of CUNY. CUNY, I think, as we all know, is the City University of New York. It's located in Midtown Manhattan. My name is Carolyn Setlow. I'm one of about 300 semi-retired and retired members of LP2. Fridays at One programs are actually funded by LP2 members. Their donations to the IER, what we call the Institute for Education in Retirement, the nonprofit arm of LP2. These are public programs offered only 6 times a year at no cost at all to the CUNY community and, in fact, to the general public. This is one way that we at LP Square give back to our community. LP2 is a non-degree program of the CUNY Graduate Center. It's a vibrant, all-volunteer community of curious minds, we think, who love exploring ideas that spark imagination. Everything from Hamlet to Hamilton and Darwin to Dostoevsky and far beyond. Our members dive into every subject under the sun, yes, even astronomy, bringing energy, insight, and enthusiasm to every discussion. Our members teach, and we also learn from each other. If you're someone who always is asking questions, who's chasing inspiration, or looking to connect with others who love learning, keep us in mind. You'll feel right at home with us. Find out more about LP Square at lp2nyc.org. That's lp2nyc.org. Or look us up at the Lifelong Peer Learning Center at the CUNY Graduate Center. So again, thanks for joining us today, and keep your curiosity alive. I now have the pleasure of passing the virtual mic to Sybil Pollet, a fellow member of LP Square. And Sybil will be welcoming and interviewing today's guest, Linda Greenhouse, who's a familiar name to so many of us, and with whom, incidentally, I should tell you, I attended religious school many decades ago. So with that, Sybil, you're on. Thank you.
And thank you, Carolyn. And now it's my pleasure to welcome the very brilliant Linda Greenhouse to Fridays at One. Linda needs very little introduction to our audience members who for 3 decades read her Pulitzer Prize winning articles on the Supreme Court in the New York Times. When she left the Times in 2008, Linda went on to teach at Yale Law School, where she is a senior research scholar. Welcome, Linda Greenhouse. And there you are.
Sorry, just had to push a few buttons. Thank you.
I invite our viewers to post questions on the Q&A function, which you will find at the bottom of your screen at any time. And we'll get to as many questions as possible later on in our program. We're so fortunate to have Linda Greenhouse with us today to help us make some sense out of the Supreme Court rulings on the Trump administration policies. This is a fast-moving story with late-breaking news, even today. So much to talk about, so let's get started. But may I first briefly lay the foundation, as we say in the business. From the very, very start of Trump 2.0, we have been seeing the president wield his thick, black Sharpie pen on order after order. The president has claimed expansive powers to impose tariffs, to deport, to say who's an American citizen, to fire agency heads, to fire civil servants en masse, to refuse to spend congressionally appropriated monies, to detain people in immigration sweeps, to terminate medical research, to require birth sex on passports, to deploy the National Guards to our cities, and on and on. And when those orders were challenged in federal district and appeals courts, the Trump administration pretty consistently lost. Trump's orders were found to be unlawful and unconstitutional. But when Trump asked the Supreme Court about 24 times for emergency relief on its emergency or shadow docket, Trump won 6-3, 85% of the time, and was therefore allowed to carry on his policies. Linda, this feels like partisan politics in black robes. Please tell us what is going on. What has happened to the Supreme Court that we used to know and love?
Well, that's actually a rather fraught statement, Sybil. That gives me an opportunity to give some context here, I think. So everybody on this call is of a certain age, I think, and we all grew up either during or in the shadow of the Warren Court, the court under Chief Justice Earl Warren that brought us one person, one vote, that brought us the constitutional requirement of school integration, and so on and so on, and rights for criminal defendants, could go on. What I think is coming clear now is that those years when the court set about to harness the Constitution as an engine of social and political progress, that was a historic anomaly. That has not been the historic role of the US Supreme Court. The court has been, at best, a trailing indicator of public opinion, and at worst, an actual obstacle to progress. And so I just put that out there so that we can all kind of take a deep breath and realize that there's a certain regression to the mean of the Supreme Court today. So how do we understand the Supreme Court? I think it's important for people to understand that uh, there are justices on the Supreme Court, a majority of them. You mentioned all the 6-3s, and there was another one yesterday, and we can talk about that, who simply have a view of the Constitution, of presidential power, of the separation of powers, the role of the judiciary, the role of Congress. They have a sincere view that it is their time, now that they have the power, to implement that view across the Constitution. I think a lot of people that I interact with seem to think that these majority justices wake up every day and say, how can I do something bad today? How can I wreck the country today? Put that aside. I credit them with sincerity. I can disagree with them. I can think they're sincerely wrong. But I think actually they are seeking to implement what they think is the proper view constitutionally of the powers of the federal government. And of course, the three dissenters, the three women who are consistently dissenting, have a very different view. And it's a view that's more consonant with precedent that's been said in the last 50, 75 years, almost 100 years since the New Deal. Those are the precedents that we've been living with and that they think ought to be retained, whereas the majority thinks the number of those precedents are just flat out wrong. So I'll stop here, but I think that may be a useful framework for people to dig into the weeds of what we're going to be talking about.
All the action seems to be on the shadow docket. Justice Kagan wrote in a dissent that the shadow docket is being used to transfer government authority from Congress to the president and thus to reshape the nation's separation of powers. Can you help us understand what she has in mind,
Right. So the first question would be, what is the shadow docket?
please?
So, um, a less freighted term for it. I mean, I like the shadow docket, that's fine. But technically, what it is the emergency docket. So every court has an emergency docket where emergencies come up and you don't have a year to deal with them. Uh, Typically, for the Supreme Court, it used to be pretty much limited to requests by death penalty inmates for stays of execution that would come up in the middle of the night on the emergency docket. Um, what this administration is doing is you mentioned all the 85% of their wins. Those wins have all occurred on the shadow docket. That is to say, they get an adverse opinion, uh, typically from the district court, the first level, and before it even can go to the Court of Appeals, they jump over the Court of Appeals, they come to the Supreme Court, they say, this is a big emergency and we need help now. Just put a stay, put a hold on the district court opinion while we carry out the normal appellate process and go to the Court of Appeals. Uh, and that's where the fights have been on the Supreme Court. Um, I gather that the administration has not come up to the shadow docket with every loss. They
Mhm.
take the ones that they think they can make a plausible argument. The other ones, they just take a deep breath and live with and take the appeal process. So the data are a bit skewed in that way, but that's what's going on. And it's important to know that the court has actually yet to rule on the merits of any of these cases. And when I say rule on the merits, the usual thing, a typical Supreme Court case is they agree to hear the case. That's called granting cert, granting a petition for writ of certiorari. We will hear your case. That sets off a calendar issue where the parties have X number of days to file their briefs, and then the court schedules oral argument, which is a public event. Uh, they don't do it on television, but it's live streamed, and the court's open to the public. Uh, so that happens in the public. Then the court meets behind closed doors to decide what they want to do. Then they circulate opinions. If it's unanimous, that's not so hard. But if it's not unanimous, the majority circulates its opinion, and then the dissenters circulate their opinion. And finally, when the thing gels, it comes out as a decision of the US Supreme Court. That obviously can take months, that can take a year. So that hasn't yet happened. It's about to happen. The
Yes.
court has heard the tariff case last month on the constitutionality of Trump's tariffs. And this coming Monday, December 8th, and anyone who's interested, they can uh, tune in to the live stream on the Supreme Court's website, supremecourt.gov. They're going to hear the very important issue of whether the president has the authority to fire without cause a member of I guess it's the Federal Trade Commission.
State Commission.
Federal Trade Commission. And there's a precedent from the 1930s that says no, actually, this is set up as an independent agency, and the president can fire the members only for cause. And the president claims that that is an unconstitutional restriction on presidential power. And that's the issue. And it's a very big deal because there are many, many of these independent agencies. And the court's going to hear that on the merits and we'll get an actual decision.
Yes, at issue in that case is the theory of executive, help me out,
The,
executive,
the unitary executive,
unitary executive theory.
right?
Thank you, Linda. Yeah, and tell us about that.
Well, so this is a theory that Article 2 of the Constitution gives I wish I had my Constitution in front of me, but basically all executive power resides in the president under Article 2. Now, that was written, 250 years ago. And as government has evolved and as the executive branch has evolved, obviously, the single person of the president is not, can have his, or maybe someday her, hands on everything that happens in the executive branch. And so power has devolved to a whole range of executive branch agencies. Um, and so the question is, when Congress established these agencies, many of which have a bipartisan requirement, so a five-member body, and I think the Federal Trade Commission is one of them, cannot have, has to have three of one party and two of another, all these kinds of restrictions, and has some ability to make rules, propose rules that are interpretations of the underlying statute that gives it power and so on. This is the so-called administrative state, or some might say the deep state. And there's been a feeling ever since the New Deal, ever since Franklin Roosevelt exercised, enormous power over the uh, economy through these administrative agencies, that it's gone too far. It has to be reined back in. It exceeds the ability of Congress to impinge on presidential power. And so that's the debate. And so unitary executive means basically Congress is disabled from placing restrictions on basically anything the president can do in his executive function in terms of being the head of the executive branch.
The other merit docket case, which you've written about, is the voting rights case, which was applied in Texas recently. And just yesterday, the Supreme Court on the emergency docket issued an order. And I'm going to ask Linda to please tell us about that and how this case, which deals with a new map drawn that the three-judge district court found to be unconstitutional because it relied on race in drawing the district lines. The Supreme Court has tossed that decision out. And now Texas can go forward with this newly drawn map. So, Linda, please help us to understand what's going on and how it relates to the Voting Rights Act. And is it not bode well for the decision that we're looking to see from the Supreme Court on the Voting Rights Act?
Yeah, so the Voting Rights Act of 1965, one of the jewels in the crown of the Civil Rights Revolution, has been hanging by a thread for years. A major part of it was struck down about 15 years ago in the Shelby County case. But what's left of it is the requirement, Section 2 of the Voting Rights Act, is the requirement that when there is a minority group that is cohesive enough and self-defined enough to elect, if allowed, to elect a legislator, whether it's a state legislature or Congress of their choice, the district lines have to be drawn to enable them to do that. Well, this, of course, gets to the boundary between race and partisan politics. And that's what's so tricky, and that's what's at issue in the Texas case. So it just happens that African Americans tend to vote Democratic. Latinos tended to vote Democratic until the last election, when in Texas, to the surprise of a lot of people, Trump got a lot of Latino votes. So White House decided that to take advantage of that, this would be a good occasion to redistrict the congressional districts in Texas, which are now heavily Republican, but there are some Democratic seats, to make them more favorable to the Republicans by capturing some of these supposedly Republican voting Latinos. There were five, or there were five districts, five congressional districts in Texas that were known as coalition districts, where there was a majority of neither Blacks nor Latinos, but together they made up a minority district that had been thought to be a pretty solidly Democratic district. So the Trump theory was the Voting Rights Act does not contemplate these coalition districts. In fact, they're unconstitutional because they have race at the forefront, and so you've got to get rid of them. And the White House demanded of Governor Abbott of Texas, you either get rid of these coalition districts or we're going to initiate a lawsuit. So Texas acceded to this and drew new district lines and got rid of the coalition districts. And the question, so the question for the uh, lower court, a special three-judge district court, was set up under the Voting Rights Act to adjudicate this. Is what they did constitutional? Is it consistent with the Voting Rights Act? And what the lower court found is uh, there was an unconstitutional use of race in drawing these districts, that under the law, race is obviously a part of every redistricting project, but the court has ruled for many years that race cannot predominate. It can obviously be a part, but it can't predominate. And the district court said, this is race, and the new lines are unconstitutional, and we revert back to the original lines that were drawn after the 2020 census. So the appeal to the Supreme Court from Texas and supported by the Trump administration is, no, you got that completely wrong. This isn't race. Race did not predominate. What predominated was partisan politics. This was a partisan gerrymander. And the Supreme Court ruled maybe 4 or 5 years ago now, a case called Rucho, that courts have no jurisdiction to get into the question of partisan gerrymandering. The partisan gerrymandering, love it or hate it, but it's not a question for federal courts to adjudicate. So maybe I'm talking too long about this, but it's really
please.
complicated and interesting. So when I read the opinions of the three-judge court, the majority finding it's unconstitutional race, the dissent, a very over-the-top dissent, but more than 100 pages, the dissent said, no, this is obviously partisan because it was the Trump administration wanted to get 5 more reliable Republican seats, and that's the impetus for this. I said to myself, my heart says what happened was bad, but my head says I think the dissent was right. This obviously was partisan. I mean, it wouldn't have happened without the partisan impetus. So it comes up to the Supreme Court, and the majority says, we think the district court got it wrong. We think this was partisan. We don't think race predominated. The dissent, Justice Kagan in her dissent for the three, says, no, this wouldn't have happened without race. Race was the kind of sine qua non of what happened here. Well, you can get a good debate going. But, a lot of people are wringing their hands over this, saying, look at the terrible Supreme Court and what they did. I think the injury here is something that happened years ago when the court ruled that we can't get into partisan gerrymandering. And that's what this was. So here we are.
So where does that leave us with all the states now in the mad race to gerrymander? The court cannot consider partisan gerrymandering, and the Supreme Court certainly seemed to be saying that any court should defer, should give deference to what the legislature did. If they drew the map, we should assume not that they had bad motives, but they had good motives. And that leaves us in a really tricky situation in terms of all of these gerrymandering, all the gerrymandering that we can expect in the South, all over the country to try to find those extra seats for 2026.
Absolutely. But the writing's been on the wall on this for years. And what the court held back in the Rucho case, with the case that said we're not touching partisan gerrymandering, is we judges don't have a metric for how much partisanship is too much. The court said obviously drawing district lines is inherently a partisan matter. There were two cases that were joined in that case, and one was, I think it was from Wisconsin, and the other was from Maryland, and one was a Republican gerrymander. And in Maryland, it was a kind of ridiculous Democratic gerrymander that had relegated the Republicans to one congressional seat in the entire state of Maryland. I mean, this works both sides. And the court said, there's no way we can tell how much is too much, and so we're just butting out of this whole thing. And so that's what's happening now. And of course, California responded to Texas by amending its constitution, which had set up a nonpartisan way to do districting, to say, we're amending the Constitution so that we can counteract Texas and we can draw more Democratic seats. And of course, the Republicans, with their bare face hanging out, have challenged that as unconstitutional, as an unconstitutional racial gerrymander. Well, good luck with that. So, it works. It works for blue states and red states, and uh, the court's not going to save us from this. Only our politics can save us.
Let's talk about the tariff case, the other case on the merits docket, because that one certainly is Trump's power to impose tariffs on any country for any duration in any amount. Where is that case going? And now, just recently, there have been some lawsuits by large corporations. Of course, the original tariffs case was brought by small companies, and now large companies like Costco and Revlon are saying, "Wait a minute, don't don't close us out of the deal. We have paid billions of dollars. If the tariff is declared unconstitutional, we want our money back."
Right,
What's
right.
going to happen, and how is that likely to get resolved? What's a likely result, and what's a likely remedy?
So I'm not really going to predict what's happening, but what's going to happen? A lot of the takeaway from the argument was, oh, I'm just going to take a drink of water here. I'm not used to talking so much. The kind of journalistic takeaway was Trump's going to lose, the tariffs are going to go down. I'm not sure, but what's so interesting from a Supreme Court institutional point of view about this case is Trump claimed for his authority a statute that gives the president some authority over various economic issues. Uh, However, it doesn't mention tariffs at all. And there's never been a case where the president has exercised this kind of broad authority to impose tariffs. Um, that's just clear that the Constitution, interpreted from an originalist point of view, gives Congress the tariff authority, and Congress has not delegated that authority to the president. President claims, well, implicitly it does, or, I have my Article 2 powers and this is what I'm doing. So it puts it really puts a tricky test to the conservatives on the court who consider themselves to be originalist. Okay, what's the original understanding? Who consider themselves to be, quote, textualists. We only go by the words of the text. Well, you can put a microscope on this statute and you won't find the word tariffs. And so, believers in the unitary executive, are they really going to say that because the president says the moon is made of green cheese, we have to rule that the moon is made of green cheese? So it's really tricky. And there was a fair amount of skepticism from the conservative side of the bench in the argument. Um, does that mean they won't find a way to let Trump wriggle out of this? I don't know. If they don't let Trump wriggle out of this, you ask, what's the remedy? So, what all these big companies are just want to get on the table, they don't want to get left out, saying, okay, we're making our claim for a refund. And there's never been a situation like this. It's totally, on a clean slate. So I don't know. But the ones who, really deserve the refund, I guess, are the poor American consumer, because, you can just see the prices going up for produce and, coffee and everything, cars. So, uh, the court's kind of in a fix, and Trump is kind of in a fix, and it's totally fascinating.
It is totally fascinating. And the word regulation, which is the word in the IEPA statute, was debated and tossed around, and they just couldn't get tax out of it. And that was
Right, right. I mean,
that was
yeah,
so interesting, and so interesting to see Justice Barrett struggle as a originalist.
yes, yeah.
That statute, yeah.
She's very interesting. I mean, um, she's the only real academic on the court. She was a law professor for a whole bunch of years and um, had a very good reputation uh, for her academic work. And so, yeah, she was pretty skeptical. But so was Justice Alito was pretty skeptical. So, excuse me. Um,
Let's talk about the members of the court. Let's start with Roberts, who's now, this is his 20th year on the court. And we have always, or so he's always been described as an institutionalist who he says calls balls and strikes. But yeah, he's the guy who has kept all of the executive power cases to himself. So he's the author of the immunity case. And tell us about that one. That's it. That's like the beginning, isn't it? Or
well,
maybe
I'm not sure I would say it was the beginning. So, uh, Roberts has been the object of a lot of false hopes on the progressive side because, he's a very civilized seeming guy and kind of benign in his personal affect. And because he did talk like, as you said, an institutionalist, people somehow assumed that he was going to be a moderating force on the court. And I'm not sure that was ever going to be the case. He's a believer in the unitary executive. He's a believer, he's been skeptical his entire life of the Voting Rights Act and very skeptical of any public policy that counts people by race for whatever reason. Um, he's had an agenda to greatly enhance the role of religion in public life. He's written, very important opinions on that score. So, yes, he wrote the immunity case, and he's written all these cases. Um, those are these are cases that a chief justice would assign to himself. I mean, that's just what a chief
yeah.
justice would do. So the immunity case, Yeah, I mean, what to say about it? I mean, there's a very interesting questions have come up now with the boat strikes, with the killing of unarmed civilians on these boats in the Caribbean, um, that there's a very good case to be made that what's happening are either war crimes or plain old murder. And this is attributable back all the way back up the chain of command to the commander in chief. Does the immunity decision reflect back to that? So the immunity decision gives the president immunity for official acts. Is ordering the killing of helpless civilians struggling to hang to a boat onto the remaining shards of a boat in the middle of the Caribbean, is that part of official business? Or if the president is immune, does the immunity extend to the Secretary of Defense and so on? I mean, it's really interesting. So that decision, set up a kind of an outline, but it didn't fill in the blanks very much. And so we don't know actually how far it extends.
Yeah. Public approval of the court is really low. Maybe you can tell me if it's has been this low in prior years. It's at the last I read 42%. And I wonder if Roberts should care about that, because certainly that low approval rating suggests that the court is out of sync with most of the country. And after all, the Supreme Court's legitimacy has to rest on its well-reasoned, even-handed decisions. And if it is viewed as being partisan, then why would people follow the Supreme Court? Not to mention the President of the United States, who says that if I don't like what you tell me to do, maybe I won't do it. So, what do
Yeah. So um, you're right. I mean, public approval of the Supreme Court these days is at a basically historic low. It's in the 40s. For many, many, many years since polling has been done on this issue, which is not forever, but say back to the 1950s, I guess. The court has been uh, the has had the highest approval of any of our public institutions. Now, it can be kind of a low bar because Congress has been down under 20% for a long time. But um, what really kind of burst the bubble actually was the Dobbs decision, the decision in 2022 that overturned Roe against Wade and enabled states to criminalize abortion. And and Roberts, I mean, I guess to his credit, foresaw that. And, he didn't join Alito's majority opinion. He was an outlier there. He wanted to uphold a restrictive abortion law in the state of Mississippi, um, but not, he didn't want to fully overturn the right to abortion. And he wrote in his separate opinion that this was going to be a very destabilizing um, turn of events, which of course it was. So when you ask, shouldn't he care? I think he does care. Um, but on the recent cases, um, he also cares about doing what he thinks is the right thing. And I'm not sure that, I mean, we all might like to think that the court's behavior in the shadow docket cases is what accounts for its low public approval. I'm not sure there's proof of that. I'm not sure the extent to which the general public has tuned in on that or really cares that much, whether the Department of Education, which Congress created, and let's assume only Congress can uncreate, can be hollowed out by the president, enabled by the Supreme Court. Um, I'm not sure that the dismantling of USAID and taking the government out of the business of protecting millions of lives around the planet, how much that resonated with the public. I mean, I think political scientists are really right now just in a muddle because because the public response to the Dobbs opinion kind of broke the paradigm that had been the political science understanding of the relationship between public opinion and the Supreme Court. That is to say, um, historically, Supreme Court decisions, even very controversial ones, have had what the political scientists call a legitimating effect, that even people who don't like them eventually say, well, it's the Supreme Court. The decisions come clothed, literally clothed in the robes of authority. So even, for instance, Bush against Gore, the case that ended the 2000 election and called it for George Bush, of course, was a very controversial decision. And there was a lot of predictions, oh, the court's never going to recover from that. Within a matter of months, the polling indicated the court had totally recovered from it. People just took a deep breath. Of course, half the public had voted for Bush to begin with, took a deep breath and said, okay, a political crisis has been averted and we go on. That hasn't happened with Dobbs. That hasn't happened with abortion, which makes sense because, you know, I mean, not to get into the weeds of abortion politics, in which I've written a great deal, but half of all pregnancies in the United States are unintended, and half of those end in abortion. So there's like lots of abortions, and lots of women coming of reproductive age are going to want to and need to terminate an unwanted pregnancy, and that doesn't go away. That's a self-fulfilling, every year with women, a whole new class of women enters reproductive age and is faced with unintended pregnancy. So the public's not going to forget about overturning Roe, and that's really interesting. I think that's where um, the danger lies for the court.
Let me invite our audience to submit any Q&As on the and we'll get to them very soon. Before we turn to the Q&As, I just want to ask Linda, is 6-3 our future for our lifetimes? Is this the court? Is there any swing that you see? Any swing votes that we used to have? And I want to ask you, if you were all powerful, what would you do to fix or not fix this court?
So your question really is, can the court save us from ourselves, right? And what created the court that we have? Political polarization and political power. I'll take another drink here. Excuse me. When Mitch McConnell announced at the beginning of 2016, right after the night that Antonin Scalia died and created a vacancy for President Obama to fill, when Mitch McConnell said, well, the Republican Senate's not going to fill this vacancy. We're going to hold it for the next president. He didn't know the next president was going to be Donald Trump. This was very early in the process, but he knew he could make a political issue of the vacancy on the court, which was this crucial vacancy of the Scalia seat. Um, so, what do I think can be done now about the court that we have? Nothing. But going ahead, I think a very important reform, if you will, not really a reform, would be to go back to requiring a supermajority for confirmation to the Supreme Court. That was the case for many years until Mitch McConnell in 2017, having gotten the White House, and Donald Trump had the seat to fill, um, the Republicans abolished the filibuster, which meant that um, to confirm a Supreme Court nominee, all you need is 50 votes plus your vice president breaking the tie. Had the filibuster been in effect, none of Trump's three Supreme Court nominees, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, would have been confirmed. And with a supermajority, a president has to play somewhat to the middle because you need the other party, whether you're a Democratic president or Republican president. So I think that going forward that's a simple rule. It doesn't need a constitutional amendment. It doesn't need, two house passage. The the Senate leadership can just do that by a rule, and that's what I would love to see happen. Now, of course, that requires the willingness to kind of unilaterally disarm the next time the White House changes hands. And I don't want to be naive about that, but I just want to put that out there for people to think about.
So let's see our questions. Jonathan Gilman asks, in a constitution whose framers were wary of political parties, isn't avoiding the question of partisan gerrymandering an ironic approach for an originalist majority?
Well, that's a nice philosophical question. But I'm not sure it actually gets us anywhere because, of course, political parties evolved very quickly in the early days of the country. So, it's a nice talking point, but I don't really have anything to say about that.
Rhoda Schlamm asks, the Supreme Court justices can be impeached for bribery, but Congress has to initiate that. At least 2 justices are implicated in bribery. If a Democratic president and congressional majority are elected, do you think any of these justices would ever be impeached?
Well, I reject the premise. I don't think anybody on the Supreme Court is implicated in bribery. Um, uh, Federal judges have been impeached following conviction for a crime, And there's nobody on the court today who's committed a crime, in my view. I suppose you're referring to the fact that a wealthy patron of Clarence Thomas has treated him to, sailing on his yacht and flying on his plane and so on and so on. But, bribery is a specific criminal offense. And there's where there has to be a quid pro quo. I'm giving you this gift and you're going to do something for me in return. And the court has been very strict about interpreting the federal bribery statutes. So I think we really aren't helped by a lot of loose talk like that.
Lisa Crystal asked if there's any chance that the court might be expanded.
Well, I don't think there's a political chance. There's theoretically an opportunity to do that at any minute because the Constitution does not set a number of seats on the Supreme Court. It's varied. It hasn't varied recently, but in the earlier years of the country, it varied quite a bit. Originally, it was 6. And it's been as high as 10, although the 10th was never actually filled. So all it takes is a statute. But the Republicans are dead set against it. They call it court packing. I don't think it would be court packing. Court expansion is the right word. So as long as the Republicans hold a majority in both houses, or even in one house, that could not happen.
Carol Groneman writes, you discussed John Roberts. Could you describe the other justices and tell us what you think of each of them?
But what I think of each of them, what I personally think of each of them really doesn't matter, but I could tell you something about each of them. Um, and Sybil, why don't you guide me through this? So, um,
Well, we know that we have two justices that are all the way on the right, whose opinions we are pretty sure of.
correct, and that would
Justices
be Clarence
Thomas
Thomas
and Alito.
and
Right.
Sam Alito.
Right. Then we have moving left, we have probably Gorsuch.
Well, yeah, I mean um, yeah. So Gorsuch, Kavanaugh, Amy
No.
Barrett, and the Chief Justice kind of um, talk a more moderate line. When push comes to shove, as you indicated at the very top of our hour, there are six justices who hang pretty much together. And, Thomas famously will write a separate concurring opinion saying, that's all well and good, but I would go further. I would take everything. I would burn down the whole house. Um, uh, but the others they're hanging together pretty well. So I think what we have is a supermajority. Just as in the Warren Court, there was a supermajority in the other direction. There's a very interesting article recently came out in the Harvard Law Review positing that what we have now is a new Warren Court. It's just on the other side of the street, you know. And so we had the old Warren Court that ended in 1969 when Earl Warren retired and was replaced by Warren Burger. And we have the new Warren Court. And in the middle of that, we had 30 or 40 years of um, not a supermajority in either direction. And so people bringing cases to the court or arguing before the court had to um, assume they were talking to a kind of a moderate middle. There's no such moderate middle today. So that's maybe the best way to describe it.
There's no Kennedy, there's no O'Connor.
That's correct. And
That
there's
might
another
might
very
be
interesting,
might be the swing votes.
yeah, absolutely. I mean, there's another very interesting article, law review article I recently read, the title of which is Where is the Swing Justice Now That We Really Need One? And the thesis of that article is that the polarization of the country and the confirmation process that I was referring to earlier really have made it impossible for there to be a moderate middle of the court in our current politics, in our current nomination and confirmation politics.
It's I've found it very interesting the role that the three liberal justices take in writing their dissents, particularly on the shadow docket where the orders, the emergency orders may be just one word, one sentence, two sentences. Uh, they're very, very brief. Today's order was 5 paragraphs, and that was quite unusual. And in contrast, we have very, very long dissents that seem to be pointing out to all of us, to the public, what the risks are. And I find it very interesting that Justice Jackson, who's the newest member of the court, and writes the longest dissents, and that's quite out of tradition. Usually the youngest justice does not dissent in such lengthy terms. Can you talk about the three women on the court who are the are liberal justices?
Yeah, I mean, there was an interesting article in the New York Times within the last few weeks about the three dissenters that I think failed to grapple with. It was very interesting, but failed to grapple with the bottom line, which is uh, they do not have the power to affect events. Uh, so to that extent, their dissents, short, long, written by Kagan, written by Jackson, written by Sonia Sotomayor, are futile. But I think the project of what they're doing is making a record for history, because history's going to look back on this period, assuming history is still turning, and will judge it. And I think that's what they are doing. And they're also, of course, speaking to the lower courts, because all these shadow docket cases come up when the courts of appeals have not yet had a chance to rule. And so, uh, when, as you say, the orders themselves are sometimes just one word or one paragraph, the lower courts really don't have guidance as to what is the rationale. And so the dissenters are providing a kind of an architecture, a framework in which lower court judges, if they're so inclined, can actually make the rulings on the merits that will come up to the Supreme Court's merits docket with fully fleshed out lower court opinions. Now, that is not always going to work. I mean, the case came out this morning. You may not have had a chance um, to read it, but it's the case about uh, one of these ability of the president to fire a member of an independent agency. Um, the Supreme Court, it's the Gwen Wilcox case, and she was a member of, I think, the Securities and Exchange Commission. Um, she was fired. She sued. She won in the district court. The Supreme Court asked the Court of Appeals for a stay. The Court of Appeals did not grant a stay. It came up to the Supreme Court. The Supreme Court granted a stay. Goes back on the merits, comes up to the, and with dissent, the whole thing goes back on the merits to the Federal Appeals Court in Washington, which ruled this morning by a vote of 2-1 that the firing was appropriate, over a very strong dissent. And, this will now, I'm sure the court will put it on hold until they decide the case that they're going to hear on Monday, the Slaughter case. But that was an example of um, uh, what happens after the shadow docket ruling when it actually comes back on the merits, and the two judges in the majority are following the majority of the Supreme Court shadow docket order, and the dissenter is following the dissent of that from that order, and we'll see what happens next.
Hasn't the paucity of reasoning in the shadow docket cases caused something of a judicial crisis? I think about that poor judge in Boston, appointed by Reagan, who really was a really good Republican conservative judge and was chastised by Justice Gorsuch quite brutally, so that for not understanding what the ruling of the Supreme Court was in this very, very short, abbreviated order. And that was a terrible, I felt so bad for him. The poor man apologized in open court. And it was
Well,
I think,
there's another way to interpret what happened, and I don't know which way is right. It was one of the immigration cases. It was, this whole raft of deportation cases, and there had been a, totally non-reasoned order from the Supreme Court, and it goes back to the district court in Boston, and I forget the details of the case, but and so yes, the judge was slammed down by Neil Gorsuch, and he, quote, apologized. People who know him, I've never met him, say that actually his apology was a parody, that he
oh,
was making fun of the Supreme Court by, oh, I'm so sorry, I'm so
oh, I
sorry.
haven't
Give
heard
me
that.
reasons, and now I see the light. that he made it actually, for people who know him, that he made a joke of it. So, but again, I mean, that kind of disarray,
Yeah.
um, uh, yeah, it's concerning, definitely.
I want to ask you whether or not you think the Supreme Court has kind of clipped the wings of the lower court, particularly in the birthright citizenship case, where the court said that lower courts that I always saw as our first line of defense, the president does something that's unlawful or unconstitutional, the district court issues what we would now call a nationwide injunction that would bind the entire country, not merely the parties before the court. And now the Supreme Court has said, Justice Barrett writing the decision, that's not okay. Can you talk about that?
Yeah, I mean, I think that actually turned out to be pretty much of a nothing because in Justice Barrett's opinion, she issued a caveat, which was this doesn't apply, this prohibition against a nationwide injunction doesn't apply if the facts of the case require a remedy outside the boundaries of the parties who brought the case. And that applies on its face to the birthright citizenship issue because what the states, I think there's a bunch of challenges to the birthright citizenship order, but I remember in the case brought by New Jersey, said we need a nationwide injunction because uh, people move into New Jersey from different states, and if they were born in a state that doesn't recognize birthright citizenship, and they come, we don't know what benefits to give them. In other words, it creates a nationwide problem that requires a nationwide remedy. We'll soon see because again, now the birthright citizenship issue itself was not addressed in that case. That was all a case about uh, remedy and jurisdiction. The merits of the president's executive order revoking birthright citizenship, which is ridiculous on the face of it. It's not going to get anywhere. But the court, I'm sure, will take one of the many appeals that are floating around in the pipeline and decide that on the merits, and then we'll see about a remedy for that, specifically.
Let me go to the questions. Um, Please comment, Bernard Belkin asks, please comment on the unitary executive theory and how it relates to the originalist theory of constitutional interpretation. Did the founders believe they were empowering the executive to do things that Congress does not support? Isn't the executive's job to execute the laws passed by Congress?
Well, that's an abstract question. I don't hold myself out as a huge expert on the original understanding. Uh, I think we have to look at the unitary executive theory as it applies to the government we have, the government that's evolved over the last 250 years, and the administrative apparatus that enables the will of Congress to be carried out by expert agencies. Um, so whatever the framers, whatever the framers envisioned about what modern life might possibly be like in the 21st century, in my untutored opinion, is not particularly relevant. And I'll just leave my answer at that.
Michael Shapiro asks, are you in favor of term limits for the Supreme Court?
Am I personally in favor of term limits? Yeah, I mean, I think it's a nice idea theoretically. It wouldn't have anything to do with our current situation if you impose term limits today, and presumably it wouldn't apply to the incumbents.
Right. And wouldn't it require a constitutional amendment?
it would require a constitutional amendment. Most people think there's an argument otherwise, but the stronger of the argument is that it would. But let's assume all that, let's assume term limits came in, tomorrow. The analysis that I heard based on the sort of actuarial tables of when the incumbents might leave, uh, that would not fully kick in until I think 20 uh, along.
My
None of us
heart.
on this call will be around to see it. Yeah.
Oh my
So,
goodness.
um, but theoretically, I think it's a good idea. The U.S. Supreme Court is the only constitutional court, high court in the world that doesn't have either term limits by years or age limits. Every other court, including some of the newer constitutional systems that have evolved, in recent decades, that have purported to follow us in various important ways, none of them have adopted life tenure for their judges. And in the 50 states, only Rhode Island has life tenure for its high court judges. Every state has a high court. Every other one has age limits or term limits. And so, uh, I think from a kind of political science point of view, yes. I mean, the framers thought they were achieving judicial independence. Uh, they had a they had a specific idea in mind, but I think they also had in mind the notion that service on the Supreme Court would be kind of a capstone of a public life, and that describes many of the initial um, holders of seats on the Supreme Court. They did not envision that people would go on the Supreme Court in their 40s, people who the public had never heard of. So, things have evolved as so many other things have evolved in a different direction. And I think, would point to term limits being a good idea.
How does Braff asks, how does the court decide an emergency exists requiring a shadow docket response?
How does the court decide that it is an emergency? Um, well, I think um, they've announced rules for this, and it has to be a case where the party bringing the emergency application has to show why intervention is necessary and also has to show why they're probably right. I mean, the merits of the question are infused with the answer to whether emergency relief is given. So, one of the issues is this the kind of case that we would agree to hear on the merits if it came to us on the merits? And if so, is this the kind of case where the party bringing this case would most likely prevail? And so when I said earlier that from what I understand, the Trump administration is not actually coming to the Supreme Court with every one of its losses, I think it's applying those rules to say, okay, if we were sitting in the seat of, let's say, the six friendly justices, um, would we get relief? And if the answer is no, they don't bother. So they only bring the cases where they can make some kind of plausible argument.
Dan Caslow writes, since Trump's tariff negotiations have clearly had an impact on foreign policy, is that relevant for his ability to use tariffs? Yet the focus of the Supreme Court questioning focused on delegation of powers. Why was that? I'm not sure I understand the question. Do you?
Well, I think he's asking, does the court approach or understand this question with some appreciation of the foreign policy implications of what Trump has done. And I think the answer is no. I mean, it was, the argument really turns on how we interpret the statute that Trump has claimed as his authority. And I think, the public policy implications, I didn't hear the argument as taking cognizance of those, and I don't think the court will.
Huh. Judd Kahn asked, do you have any idea what kind of country the 6 Republican justices want to live in?
Well, I mean, come on. I take them at their word, read their opinions.
Is there any good takeaway from all of this? So we
Sorry?
don't
I didn't
any
quite catch that.
good. Is there anything positive that we can say about where we are as we come to the close of our session?
Well, I think one positive thing is that people are paying attention to the Supreme Court. Typically people don't.
Yeah,
And
that's
I
certainly
think,
that's certainly true.
in 2016, so Mitch McConnell has claimed that the thing he's most proud of in his political life was holding that seat open, holding the Scalia seat open as a way of motivating the Republican base to come out and vote, knowing that who was in the White House was going to be in a position to control the Supreme Court. And he's right about that. He deserves to feel proud of that. That was his goal, and he accomplished it. There were efforts on the Democratic side to motivate the Democratic base in 2016, saying, look, there's this vacancy on the Supreme Court. The Republicans have refused to give a hearing to Merrick Garland. We've got to vote. We've got to hold the White House. That didn't happen. So people just weren't paying attention. And I think now they are. So I think that's a good thing. Whether you think the court's doing the right thing or whether you think the court's doing the wrong thing, I think the public is now part of that conversation to a much greater extent than it has been for many, many years, and that's a good thing.
So you've raised the question in styling this our discussion today. The Supreme Court, protector of democracy or obstacle? Where do you come out?
Well, I mean, that's a really good question. And I don't have a clear answer to it. I think the court, I think we have to take we collectively, the public, have to take responsibility for having created the court that we have. It wasn't foisted on us. We collectively elected the people who chose the people who were sitting on the Supreme Court. So to that extent, you can say it's a working out of one aspect of the democratic process. It's not a perversion of democracy. But obviously there's a number of people on this call who are, truly and understandably very upset with what the court is doing. And I think the answer to that is to work in our democratic institutions going forward and get us a court more in line with what we would like to see. I don't think there's another answer, but to go back to the remarks I started with about the anomalous role that the Warren Court played when it helped itself to an interpretation of the Constitution that, I think many of us would say enhanced democracy. That has not typically been the court's role. And the court is not really set up to save us from ourselves. There's a slogan in the deportation crisis, and it's in Spanish. And wait a minute, I'm going to hold something up. Okay, I'm not getting a good view here, but
Could you
it's
tell us?
I'm in Los Angeles, and it's actually a poster that says, "Solo el pueblo salva al pueblo." Only the people can save the people, right? Only we, the people, can save us from a Supreme Court that we think is off on the wrong track. Only the people. Solo el pueblo salva al pueblo. Only the people save the people.
So let me just see if we are.
Here we have better view of this.
Oh, yeah, that's wonderful. Nancy Small asks, what law students at Yale, to the extent that you have connection with the Yale law students, what concerns do they have about the future of the courts and our nation?
Oh, I couldn't really channel their concerns. I mean, they're concerned about getting a clerkship and getting a job and paying off their student loans. A number of them want to work in the public policy sphere, and I think some of them on the progressive side are concerned about what the public policy sphere is going to look like. But no, I wouldn't take their temperature.
Yeah, no, but one would have to think it would have been such a wonderful thing to go work for the U.S. Attorney, for the Justice Department. And those are places now that I think many young people would have second thoughts about.
Well, I think that's really an issue. I mean, not only in law, I mean, not only in the Department of Justice. I think, I remember when I was in college, majoring in political science, I thought, going into government service would be like a wonderful thing. And, when you see, senior civil service people just being summarily fired after decades, or anybody being fired, for raising a question about anything that's happening inside the government, you have to wonder whether, who in the coming generation is going to want to work there. So I think that's a real problem. I mean, many of us on this call grew up thinking that would be, the highest and best use of our talents to work in the public sector. And I hope that's still true, but it's certainly a lot of questions have been raised.
Ellen Koligar asked, do you see any threats to separation of church and state in the recent decisions of the Supreme Court?
Oh, I think that's a major crisis.
Yeah.
I take that very seriously. I think the kind of one step at a time decisions that have all been written by the Chief Justice and have all been enabled by a whole network of religious litigating groups that are really smart and are very well funded and are creating these cases to serve up to the court. the baker who wouldn't bake the cake for the LGBT couple, the website designer who wouldn't design, the football coach who insisted on, kneeling
Taking
on the
his
50-yard
knee.
line and saying a public prayer. All these cases, I mean, these cases are inherently phony, but they come up to the court and the court takes them seriously and uses each one as a little wedge, a little scalpel to kind of carve out a new hole in the wall of separation between church and state. And a lot of these are kind of under the radar, but I think um, moments of truth are coming. A lot of states now have these Ten Commandment requirements that the Ten Commandments have to be posted in every classroom. I think in the Texas law has to be posted in such big print that it can be read from the back of the room. Uh, these cases are coming to the Supreme Court, and there's a precedent on the books that say, no, you cannot require posting of or you can't even have posting of the Ten Commandments in a public school classroom. And so the effort is to overturn that, and we'll see soon enough.
Oh, I'm just reading from Ruth McAmen. Breaking news, the Supreme Court agrees to review Trump order restricting birthright citizenship. Was the decision expected? Do you think they will agree with Trump? How would it be implemented?
Yeah, no, I'm glad to hear it because there's no way that the Trump order is going to be upheld. There's no way. So it'd be very good to put this to rest. I'm glad they've taken it. I don't know from what you just read which of the several cases they've
Yeah.
taken, but obviously they've taken it in time to decide this term and just, put the nail in that particular coffin. So that's good news as far as I'm concerned.
Well, this confirms what the good point, the optimistic statement you made that now we're all thinking about the Supreme Court. We have people
There's,
who,
there's, yeah,
in the midst of a call, get late breaking news about the Supreme Court and bring it to our attention. So
good,
there,
good timing. Okay, very good.
good timing. There you go. Well, it's 2:25 and it's time for me to thank you so much. This was really, really terrific. And I do appreciate your teaching us, chatting with us, explaining to us.
Well,
Um,
thanks for having me.
it
I've
was
enjoyed it.
really, really wonderful. Today is the last of our Fridays at 1 for this semester. We have an exciting program in store for you following our winter break. On February 6th, our speaker will be William Easterly, a celebrated economist. His latest book, published only a month ago, is Violent Saviors, The West Conquest of the Rest. The Financial Times says that Easterly offers a new and urgent perspective on global economics and has named Violent Saviors a best book of the year. So it's, I guess, time to say that I hope that you will join us on February 6th. And in the meantime, we wish you a very, very happy holiday season. And with many, many thanks again to Linda Greenhouse. This was wonderful.